Texas, or online, irlonestar.com.
You are listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe, and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection with Tony Sherritts Collins and Cheryl Ellsworth Jahani. We are two Texas licensed attorneys. We are here every Tuesday from 12 to 1 on 104.5 and 106.1 Conroe's FM. And this is a legal show, the Legal Connection. Today, Tony, we're going to be talking about mistakes when buying land. You said that you've had a lot of clients contact you recently, and there's an activity like some activity going on out in the community that people are.
Well, it's not just in the community. It's like all over Texas. Interest rates are really low right now. I mean, as low as they get. The housing market is booming. The builders are going crazy because of COVID. A lot of people are staying home. They want larger. They need a place for their kids to be taught at home. They realize that, home basically is where the heart is. And so the Home Depot, just the litany of builders that are out there, they're buying land. And so consequently, people are looking to buy land to build their homes or improve or whatever. But right now we're talking about land because I'm getting a lot of calls because we're in Montgomery County and there's lots of land to be bought. Not as much here as there was, but big chunks of land. Like they have the Grand Lake Estates, you'll see on the that somebody's actually gone in and bought a big chunk of land and already subdivided that into big chunks of land that they're selling. But if you get out into Grimes County and out toward the hill country, there's still a lot of land that's ranch.
Right.
I mean, it's like big 500, 600 acre tracts, and I don't know who has the money to buy that kind of thing unless it's cheap enough or you inherit it. But and then you want to know this what we're talking about today for selling purposes also. But when I've had people, when you go buy a home, advertising, and you'll get a realtor, hey, look at the MLS, look what I've got for you, it's a great deal, you can afford this, FHA loans, nothing down, you can move in, and then you get yourself in trouble because you don't have enough money to pay your mortgage because you barely, got yourself into the financial situation, and you're hoping for the best. But I'm getting ahead of myself. Many of the homes that they're selling between, say, $250,000 and maybe $800,000, that seems to be sort of a general range of home ownership in the Montgomery County area. A lot of times you're better off if you just buy land and build it yourself.
Why would you say that?
Well, because look how many people are making money when you're buying from I guess it's economies of scale with the builder. You can get a tract home, but
say like that Grand Central Parkway over there that is just, they bought it, they developed it, and it's just and there's house.
They're all over Montgomery County right now.
$500,000, Tony, for
basically what's a zero lot house. And so why wouldn't you go find your land and find, like even Grand, I haven't priced Grand Lake Estates, but let's say it's $5,000 an acre and you buy 10 acres. That's $50,000 for 10 acres. Maybe it doesn't have utilities. Maybe it doesn't have, you maybe have to drill your own water well, but still, if you do the math, you may be in a better situation and have a lot more freedom. You're not going to be subject to homeowners association rules because they haven't been created yet.
Right.
You may have a lot more freedom if you just go buy some land and build it yourself. And I say build it, you may not be a contractor, but hold it for a while and look into it. A lot of people can't afford that because they're being baited into, here's what you can afford, the zero down, we've already got the house ready, you can move in with your little family, let's go. But if that's not how America was made. America, people, they came in.
We want space.
There was, I guess, a lot of stuff was going on in the 1500s, 1600s, and there was all the exploration. And we've been watching all the Borgias and the Medicis, or Medici, or however you pronounce it. We've been reading a lot of the history about why there was exploration and, people actually were trying to find a different place to live. And maybe not unlike what a lot of Texans are thinking now with the new administration, because Texas is the only state, because we entered our ownership by treaty, or we entered our statehood through treaty. We're the only state in the United States that can legally secede.
Right.
And then Jim was saying, my beloved Jim was saying, well, if we did that, we could be 5 states, but the 5 major communities in each section would probably be a majority Democrat, you'd have the San Antonio, the Dallas, the Houston area, Midland, all of those. I'm not sure if Midland's Democrat, but you may end up in the same ball of wax that you were in, if you're not happy with, socialism or whatever we're doing and,
Right.
with the administration right now. But that being said, that still goes back to buying large tracts of land. I'm getting a lot of calls on that right now. Tom Ball's got large tracts of land, Grimes County, Waller County, and people are saying, hey, I need some help and I need some guidance. And so that got me looking into it. And the people that are calling me are very well-educated, intelligent, and reasonable, but I've taken a lot for granted from my background because I was a landman for 20 years.
Right.
And I was just accustomed to going out searching and making it so that with the due diligence and the financing, if the guys that I was buying it for didn't need financing, they would just buy it outright. But make sure everything went properly and smoothly for the closing of large tracts of land. It was primarily for minerals, but the perk was they got the surface too. Now, the people I'm helping right now are looking for surface, and they're not as interested in minerals, but minerals are important. Why are minerals important? Because minerals have a higher, they have a, what is the term I'm looking for? They have the predominant rights to the surface. So if I own the mineral rights to the land that you are on right now, the tract of land that you own,
can come tear up my surface.
I could go, I have the right, if there's not a better reasonable way to mine my minerals, I have the right to go into your property. We are co-owners. You just happen to own the surface and I own the minerals. And minerals is not just oil and gas, because there's lots and lots of ordinances and statutes, particularly in Conroe and city of Conroe and Montgomery County, saying where you can drill. And, throughout the years, they've made it so you can't be like the Beaumont in the 1900s where there's a derrick in your front yard.
Right.
But oil and gas is not natural gas and oil. They are not the only minerals. There's coal, there's gold, there's silver. What if some other mineral they've determined is in our soil that can only be surface mined in your front yard? I can go in your front yard and dig your garden up if I own the minerals. So that's kind of an important thing to look at too.
Right.
But what we're looking at today is the top 10 things you need to look at if you're interested in buying land in Texas. And so these are some of the pitfalls. So what is the first and most important thing to look at and consider when you're buying land in Texas?
Well, I mean, it's not on this list, but for me, it would be location. But
okay, that's true. That's true. Well, that's the first thing. But once you've found your location,
okay.
So let's say you've found your Shangri-La, or maybe it doesn't even look like what you want. Maybe it's it's a desert, but you've had some ideas. Before you can do anything with that land, the first thing you need to look at is what?
Well, the due diligence. Well, I mean, you have to look at the records on the land, but here it says one of the top 10 mistake is inadequate due diligence, which is what you're leading into.
Right.
Actually.
It is absolutely the worst thing that you can do is go into a piece of property and it just looks beautiful, and then just be so excited about it, like a dress on the rack that's
right.
A designer dress that's marked down to like next to nothing, but it's really made of paper. And it's going to disintegrate after or some sugar thing, and it's going to disintegrate after one wear. I don't know.
Right.
Or you get something really cute at like what it used to be. I don't know, 579 or
579.
And the clothes were made, they're not the quality,
cheapy.
like
it
Versace.
Was a junior
So
shop.
that you're paying nothing for it, but you're getting a cute one wear item.
Sure.
Because once you wash it, it's going to shrink it or
right.
fade or whatever. So inadequate due diligence before contract negotiations is the most important thing you should do. And after you look at it, don't still be married to it. Be willing to pass the deal if it doesn't meet the requirements that you have. You may want to use it to put a dry cleaner on it, and there may be something that says you can't put a dry cleaner on this land because that ruins the land with the chemicals and stuff going on. You may want, somebody may have already entered into a co-op agreement with a cell phone tower utility, and they have the right to put that cell phone tower right smack where in the middle of the property, and that's where you wanted to put your $1 million farmhouse that you've envisioned. So if you haven't done the due diligence, you need to know that you would have bought into a problem. And so the first thing you want to do is the first thing you want to avoid is not spending enough time on the ground to see all or most of the property's attributes, whether they're positive or negative. That's the first thing about your due diligence. You want to walk that property. Sometimes brokers and buyers will do only a drive-by to tour like a ranch or land, and or either just pass, or they'll pass on the property because of that. But they really need to look at all of it. There may be more to it. If a prime property hits the market, priced well below the fair market value, acting quickly makes sense because you don't want to lose the deal. And people lose deals all the time, because somebody's watching it. And you want to be that person that jumps in. But that's rarely the case. These are kind of few and far between. By that time, if it's on the market and it hits, and it's actually hit the market for you to make a bid, it's more likely than not that there's something up. There's an underlying contract that's already been made. The parties know each other, so beware of that. But there's almost always time to give a property a full look if it's legitimately available, and even for larger ranches. Okay, for larger properties and properties with lots of tree cover and or topographical variances, a quick drive-by around the front and easily accessible parts of the ranch is not adequate. It's just not, because you don't know what's going on the inside.
Right.
Who knows what's going on the inside? You'll likely miss important features or potential problems. Large ranches can sit on the market because the listing broker or buyers didn't take the time or effort to explore the entire property. Getting to the back area, spending hours on the ground, tromping through brush, woods, down creeks, can result in discovering hidden assets that other prospective buyers miss. These hidden assets include springs, creek branches, waterfalls, scenic vistas, rock formations, home sites, wildlife, none of which are part of the standard tour of marketing. So you really just, the bottom line is you've got to put boots on the ground to look at these properties. Take the time to explore fully the properties you're interested in. It may pay off with hidden assets ranch at a price similar to ranches without those assets. So you don't look at it. The problem, a lot of these properties people ask me about right now, though, they're not these massive ranches with that are tree covered that you've got to go to Google Earth and look at, which I think is a very, very good thing to do as a landman. You want to get on Google Earth Pro. You can get a free, just for 1 or 2 times. It doesn't cost you anything. You can just download it. And you can put a timeline in there. You can go back to, in this area, 1978. And you can put the year you want to see what the land looked like from a satellite view.
Oh, wow.
78 is really kind of black and white. The technology changed so much from 78 to now.
Yeah.
And it's interesting that we were just watching the movie 1984 in all version. Have you read that book?
Years and years ago.
Well, let me ask station manager Dick if he's paying attention. Have you read the book 1984 or watched the movie?
I haven't seen the movie.
Yes.
Okay, so which, the book or the movie?
I've seen both.
Okay. Well, there's a
one.
more recent 1983 movie. We watched the one that was made in 1953. Well, 1984 was written by George Orwell in 1949, a year before his death. And the idea came from his wife. And this is another little piece of trivia which is just dumb, but his name wasn't George Orwell. His name was Eric Blair. And he had dropped out of school, and he finally got his degree. I don't know his whole history, but he wasn't the best student, but he was a pretty good writer. And he changed his name to George Orwell, which I always get him confused with Orson Welles because they kind of wrote about the same things, War of the Worlds and all that stuff. Let me ask you this. Maybe
Orson
you would
Welles
know.
was the
Why do you
actor.
think he chose the name George Orwell
Rather than
as
Eric.
his pen name?
Rather than Eric
Blair.
Blair. George Orwell. I don't know, because it sounds like an old school classy name, like
Orson Welles or...
not Orson Welles, but who's the common law? Oliver Wendell Holmes. It always kind of reminds me of those kinds of names.
No, it was really just a kind of a sensible reason. He said he wanted to be, before he even started publishing, he wanted to get his books published, and he wanted to write famous books. That was his goal from the time he was in high school. And he said, if you put my books on the shelf, A is going to be too high, and C is going to be too low. So I was right in the middle.
Right eye level.
So he chose George Orwell.
Well, that was smart. Yeah. That's like people today choose names that starts with the A so that when you're Googled, it'll come right up.
Right. Or it used to be in the phone books. Now in Google, I think that's kind of thrown that out the window a little bit. But he died at 46 of tuberculosis. And he knew he was famous, though. But he was really famous after 1984 in Animal House, because he wrote them based on his experiences in World War II with the Russians and how England was aligned with them. He thought it was wrong, and that's how he made up all the characters. So everything he wrote about was based on his take of political activity and him putting it into a more of a storyline, using the icons of animals and Big Brother and all that stuff. But anyway, I'm kind of getting off track. But he, 1984, we were talking about technology. If you use
the Google
Earth Pro, you can actually go back to the year 2008, the year 2010, 2012, and you can see what's going on in the area, and you can see when stuff's being cleared and if there's any creeks and, is there a utility that's been on there that was not, their easements can be placed on, I think we talked about this on another show, the Texas Gas Utility, the only gas company in our area, had put one of these gas plant stations on one of my clients' property and didn't ask and didn't tell them. They just put them on there.
Right.
They can't do that unless there's an easement or they've gone.
Was there an easement there for them to do that?
There was an easement on the survey plat, which we're going to get to. Also, you need to really, really review your survey plat before you enter a contract for property. But there was an easement for not for that purpose. It was very clearly defined in the actual survey, there was no written easement. The easement was in the survey that was filed of record at Montgomery County. But it didn't say that the utility easement wasn't for the purpose of putting in a gas plant. No easement would be for putting in a surface gas plant, maybe for gas usage running underneath and, but no, that's not what they did. They put an actual gas plant on this property and they built it up and had a big old fence around it, and you could smoke cigarettes and maybe, you could explode or, if you dug and hit a line, which is another important thing to do. Before you dig on your property anywhere, no matter where you live in Montgomery County, because of all the gas lines and things that were, buried years and years ago, you may not even know about. I think the number that you call is it 311? Do you know the number? It's either 611 or 311. I can't remember.
It's 311.
311. Before you dig, you call and the city will come out and give you and let you know that it's okay to dig, and you want to do that.
Well, I know that 311 is for code encroachments and code violations.
I knew it was. There's 911 for one thing and 611 for another, and there's all these different 11s. But okay, it's 311. But definitely before you're digging a pool, and your pool contractor should know this, but a lot of people don't know this. Maybe you're just digging to put some post in. Maybe you're putting up a bird feeder or you're doing something on your own.
Right.
You definitely want to call because you don't want to hit one of these gas lines. And in this case, they put this gas plant just in the middle of this treed area.
Yeah.
Before 2978 was made into a road. It was a dirt road when my clients, their parents had gotten the property. And so now it was on a main thoroughfare, but they didn't know it was there because they don't live out in the area. And this was to provide gas for the Westwood subdivision, but everybody, their claim was, we can put it there. We've got an easement. It's here on the plat. But the easement ran through everybody's backyard. So if that logic held, everybody that had a 50-foot easement in their backyard was subject to the gas company coming in and putting a gas plant back there. They could just, and who would expect that? 50-foot easement having a big barbed wire, looks like a prison gas plant in your backyard.
I remember the pictures.
So, and we were probably going to win on that, except it had been there for or at least they alleged it had been there for just over 10 years.
Oh,
and that's they can adversely possess on it if you don't ask them to get off
before the 10-year.
And so there was another. We had a different take on it. We could have argued a different. What was it? It was. I can't remember what we argued. It was a really, really good argument, and it stopped them in their tracks. But my clients were like, we're not willing to fight the big, 5,000-pound gorilla. We just can't do it, which was wise and something I suggested strongly.
Right.
Because we're going to be in litigation for 20 years, and we're all too old to be in litigation for 20 years over, like a little 60 by 50-foot tract if we can somehow negotiate something. And so, but the way we knew, they pretty much lied and said that, when they built this thing, the way we knew when it was built was using Google Earth Pro. I was able to see land clearing back just at the 10-year mark. And so I don't believe that they actually had met the 10-year adverse possession time, but it was going to be, then they started providing us with documents that looked like they were doctored, showing, we've got this, we were actually moving dirt, 2 days before you filed this suit 10 years back or whatever. So, So we ended up settling with them. But that's the kind of thing you're looking for, is you want to go to Google Earth and look at what's going on above you. And it's another way of not having to have a drone to look at it. And Google Earth is updated with the satellites they have right now practically every year. So you can just kind of look at it that way. The GIS maps with MCAT are pretty good, but Google Earth Pro, they don't give you the timeline. They only give you, they'll go back to like 2014, 15. A lot of times you want to go way back because of oil and gas drilling and that kind of thing. So just you do want to look at your property, and another way to do it, another tool, if you can't actually get on it because you'll be trespassing, perhaps if you are looking at it and you haven't gotten access by the landowner to look and you're just kind of kicking tires, go to Google Earth Pro. It's really good to do. On the downside, failing to see all parts of the property may result in missing trash dumps, fences down or in disrepair, signs of trespassing or poaching, misrepresented live water or strong springs, oak wilt, areas of property that are significantly inferior to the guided tour that you were given by the landowner or the real estate agent. And other factors important to the buy price or the pass decision before you enter a contract. And I'll add that I learned this week when I was doing like a Zoom CLE that water rights are really, really important.
Right.
And tell me if you knew this. I did not know this, and I should have known it as a landman. Who owns that water on the property on one of these tracts? Let's just say it's you see a gully on your property, and
then the gully has water in it.
Yeah, and let's just say that they said, when it rains really hard, it floods and there's a lot of water in it. Who owns that water?
Well, I think it depends on what water district it comes from, doesn't it?
Well,
or water authority.
Yes and no. Who owns the water in San Jacinto River Authority? Who owns the water in Lake Conroe?
Well, it depends on where it comes from.
That you go to the source.
That's what I'm saying.
Water is almost all water is owned by. It's not owned by the landowner because if it comes in, it's the water is, and I forgot what the term was.
Well, Colorado water is the water that's supplying Arizona. They've contracted it all out, and so the people in Colorado are fighting over water that's been shipped out.
Well, I'll give you an example for Lake Conroe, since that's the example that came to mind. Lake Conroe, if you have Lake Conroe water is not owned by it's owned by the San Jacinto Water Authority, and the water was trapped by free flowing water, but because it was state water and it was trapped, they have an agreement, I think, with the state. And I don't want to get too deep into the ownership, but the bottom line is if you've got if you have a house on Lake Conroe, then if you want to use the water to irrigate your property with a sprinkler system, why wouldn't you? It's just there for the use. It's not salt water. You could. You have to get a permit from the San Jacinto Water Authority, and you have to go to the stateoftexas.gov or whatever, and they've got the permits, and you got to pay for it. You can't just, unless I guess you could if no one knew about it, but you're not supposed to because you don't own the water. On the other hand, if you're catching rainwater, or if it's coming from the sky and you catch it on your land, it's your water. So it's the rule of capture. If you capture the water, it's yours. But if it's flowing from a different stream or off a mountain, it never was yours. It's just flowing through your land. And which goes to another thing. If you're buying property on a lake, if you own property on Lake Conroe, you get a meets and bounds description of your property, just like, here it goes 50 feet out from the street line or whatever it may be, whatever the description is in your survey. The rules of egression in, I don't want to say egression, it's and I can't remember the term, but it's riparian rights, and there's the other side of it. It's the river rights and water rights.
It's how it moves.
Yes, if the river shifts or your bio shifts, it's there are rights with regard to what land you own if the river shifts. Right. Do you own the and it goes that I have.
It's like the erosion and the impediment or something. How
right. So in Galveston, they've got beachfront property, and then there's a hurricane, and now it's eroded, and so now your beachfront property that used to be 100 feet in front of your house is now water. So did you give up that land? Well, yeah. I don't. Your contract would probably say, and there's probably some rules down in Galveston, but the same logic applies, or the same law, common law, applies to Lake Conroe. And so if the water goes down because they've reduced it for the usage of people to have water rights during a drought, then you've got a lot more land on your property.
Exactly.
Because your pier is no longer in the water. Your pier is on land. And what if it stays that way for years? What if, and that happens up in northern Texas where you've got this land that is now dried out. It's a dried riverbed or whatever. Do you own that riverbed? Well, in the case of lakes, you don't, because there's usually, I think there's a state statute, but there's also probably going to be the water authority, and there's various statutes you have to look at. So you want an attorney to look at it. But the way it works in Lake Conroe and Lake Livingston and there's various other man-made lakes, which is another point of interest. There's only one man-made lake. There's only one natural lake in Texas. Did you know that?
There's only one natural lake in Texas. Let me think. Which one would that be?
Do you know? Station manager know? Okay. Every other lake is man-made. Only one natural lake.
Well, I mean, okay, my first guess being from Dallas would be Texoma, but I'm going to say over in Austin.
Texoma? I thought is that close to Dallas?
Yeah, Texoma is a lake that's shared between Texas and Oklahoma.
Oh, I didn't know that.
Beautiful.
Oh, I'm thinking there's another one
beautiful
that's
lake.
another one that's down south, because I remember they just created it like about 20 years ago, and
Joe
there were tree
Pool?
stumps in it.
That's
I can't remember. It's Tex something, Tex Arcana or something.
but is it in Austin?
no,
the
no,
natural
it's
lake?
south of here.
Well, south of here,
Yeah.
this natural lake?
I just can't remember.
Gosh,
but
south of
it's
here.
not Texoma. In fact, I would never even have known. I thought Lake Livingston was natural. No, they create it by damming up the Brazos and all these
crazy?
rivers. And no, the only one is Lake Cato.
Are you
And
kidding me?
close to Dallas. It's between here and Dallas. It's in eastern Texas.
So it's not south of here, it's north of here.
Right. The only natural lake. No, I was talking about the only one I was thinking of. The only natural lake is Lake Cato.
Oh.
At Cato.
Are you kidding
No,
me?
and Don Henley wrote a lot of songs about it because it's a beautiful
Oh my
natural lake.
gosh.
But yeah, it's the only one, and all the rest are man-made. And so the same law applies. So that if the lake goes down because they're using it for a river authority or for whatever, and that's usually why lakes are made, because they're used for some purposes of irrigation, like the Romans did back, with their aqueducts and all that stuff. But we don't have aqueducts here. I think we have underground aquifers and that kind of thing. But Lake Conroe, if it goes down, you don't own any more than what your description says, and if it goes up, it's kind of scary
You lose
too.
some.
You lose some too. And remember the most recent Hurricane Harvey, everybody, and the fights and the lawsuits, going back and forth about releasing land, and people's land was ruined. I mean, it's a whole different show, but I think they ultimately failed on that. I think they're still in the courts over. I think each subdivision had a different thing depending on what the developer knew when they bought it. If the developer knew that they were in a floodland and they let it, and they didn't disclose that, then they had a disclosure issue, and that's how they're winning some kind of settlements in these cases. But there was no fault by the San Jacinto River Authority or the flooding opening up the gates, because it was a decision that was made by the government, and the government is like 1984, the movie. They're powerful, and they will get what they want ultimately, unless you want to fight for the rest of your life, and nobody wants to do
lose, right?
that. Okay, so just little tidbits.
So if
of
we've
information.
done our due diligence, right, and all these things that we've talked about, you've said that the next thing is failure to update or modify your contract
Right.
according to TRC.
Right.
TREC.
The TREC forms. Okay, so you can enter a land contract, and many developers have very high-paid attorneys that have their own form contract. I have form contracts for people too, and I'm not a high-paid attorney, but when I worked for the different oil companies, and I worked for very large ones and small ones, each for about 10 years, and we had our own form of contract, whether we were doing farm-out agreements or joint ventures or just purchasing ranch land. We entered into a contract that was, I guess, esoteric to what was needed for that ranch, and they were out in like Blanco or New Waverly, but they weren't the standard TREC forms. But you can use a standard TREC form,
Right.
And standard TREC forms are wonderful. And TREC stands for Texas Real Estate Commission, Texas Real Estate Commission. Right. I was trying to think. I always just say TREC. They've got promulgated forms that are put together by attorneys that are or fill in the blank.
And they're available online.
They're available online. You just go to TREC if you want to buy a tract of land. You don't have you want to do it on your own, let's say, and that's it's not a bad thing to do if you want to see what things you need to look at first to get a head start. And you can fill it in and go forward. And TREC's got all kind of forms available to lay people. It's an amazing agency. You can get to buy your house, to lease, to rent, and it tells you what other addendums or options. And you can just go in. It used to be before the internet, you'd have a real estate agent to get these for you.
Right.
Now it's interactive. Now they may not be completely interactive if you're not an agent, but I think they are. At least not all of them are. But give it a shot. Go there and just take a look at it. So if you use your TREC form or if you have your own form to buy the property, if you've gone in and you've made an offer, and it's been subject to certain things you want, like I'm making this offer subject to this being a deer ranch, or I want to ranch cattle, and then you find out later you can't, there's a non-compete next door and you can't have cattle there. I don't know. There's something saying that you can't do what you want to do with it. Well, that's a pretty standard thing that you would put in a contract. This is the use I want it for. But what if you find out something else about it after you do your due diligence? Don't just say, oh, well, it's over. Go in there and be willing to pass and ask to amend the contract. More than likely, if you present this to the seller, they're aware of it and they may have disclosed it, or maybe they didn't have to disclose. There's a lot of things that sellers don't have to disclose. Lots of them. Like your developer doesn't have to disclose a lot of things because they're an exception to the property in the Texas Property Code. A developer doesn't have to, if it's a new property, there's a lot of things they don't have to disclose. So even when you're buying a subdivision lot, you want to maybe have an attorney look at the contract for you or read it very carefully because of these disclosure rules. And a developer can basically get away with murder for a lot of things. The developer may not tell you that they don't have mineral rights, and then the mineral owner comes back and wants to dig for something in your front yard. Because they don't have to disclose those things.
Wow.
So you want to be really careful about that.
Right.
So it doesn't, but it could be that in your statute or your county, there may be an overlying ordinance that requires them to disclose it. But and I don't know that for sure. I'm just saying in general, beware because a lot of things that you expect to be disclosed and they don't have to be disclosed. I can almost guarantee when there was the flooding, when the developer sold this land over there by Addicks Dam and all the people that got flooded over there in Kingwood. I'm going to just guess that the developer didn't say, oh, by the way, this isn't a flood zone.
They can do this, right.
Because they didn't have to. But that's why you get the seller has insurance for something like that, and they can offer you a buyback and some other stuff. But anyway, beware of that. I don't want to get into the nitty gritty because everything is different. Everything has got there's some special thing that I can't even imagine is going to happen also in every deal.
Right.
So anyway, the bottom line is many buyers and brokers simply fill in the blanks and sign and submit. That goes for a contract just to buy a home or for land. And this could apply to almost any, car sales too. Don't just rely upon that, really look more. This is almost always a mistake and potentially a costly one for any agreement that you enter. Just don't rely upon filling in the forms. Really read it before you sign.
Right.
Don't be in a hurry. Take it home and read it if you're not understanding it.
Well, and aren't you saying that there's a part where you need to consider changing the language, that if the buyer changes his mind, the seller can force the buyer to
you want
purchase
to look,
under the terms?
You definitely want to look at the terms that are in the TREC forms because the TREC form is very pro-seller, in my opinion. And so you need to make sure that you look at the stuff that's not fill in the blank. Because in the TREC form, it says that for farm and land, that if the buyer can't just back out, there's certain reasons they can do that. But if they find out that there's not a use and you didn't put that provision in there that you want to use it for, if there's something that you didn't account for, but now you want to back out, you may not be able to, and they can get specific performance or penalize you for having it taken off the market. And what if the market turns and now interest rates are really high and they can't dump this property and they want specific performance?
Right.
They can go after you and get a judgment. You may not be able to afford the land anymore, but they'll still get a judgment because you made a deal.
Right.
The TREC Farm and Ranch is a standard contract used by the majority of land buyers and sellers. It just is because there's just so much out there. And I actually like the form myself. Certain certainly, on larger tract, a buyer can have an attorney draft the custom contracts like we were talking about earlier, but sellers and brokers are instantly at ease with the TREC contract because it's been used so much, because they've seen it and they can read it. And it's like, okay, other people have used this. The TREC contract, while a good form overall, is deficient in several areas, including provisions pertaining to the title, objection, and waiver deadlines. So you want to look at that very specifically on what you want to waive and what you don't. Read it carefully. It's clear English. It's not hard to read. The closing date, the closing documents, default remedies, seller representation, survey provisions, document production, and some boilerplate items. You're thinking, oh, well, everyone says before. No, read them, because you need to choose the option that's best for you, all right, depending on whether you're the buyer or the seller. Under the TREC contract, if the buyer defaults, the seller can force the purchase of the property and/or seek other remedies provided by law. Liability extends significantly beyond the earnest money contract. That's the most important thing that you can learn from this show, other than what we talked about earlier, that humility is the most important virtue. Be humble don't think you know it all, because people don't like that and they're not going to work with you and they're not going to like you very much. Even though it kind of works to be strong, that's different from humility and pride. Like saying that's my way or the highway, because it's never your way or the highway in negotiations. So if you sign a contract, your liability is going to extend beyond that contract in almost every situation.
That's right.
So be careful what you sign away. Very, very important. To say, and we've gone over this before in other shows, to say, I didn't understand. They're the person that knows, because they're my agent didn't tell me. No, if you sign it, you're bound to it. Don't try to get out of this by saying I didn't know. That's never going to fly. Don't sign it unless you know what you're signing. These items, the items that we're discussing above, can be easily addressed in an addendum. And if they want to make the purchase and you find out something's wrong, then there's a ton of addendums through TREC, or you just may want to add something if you don't know how to word it. If you don't know how to word it legally, go with the addendum, because it's already been worded for you. It's happened before. Don't recreate the wheel. But the addendums typically can be negotiated by the parties. But pushback against any changes is rare. Usually people are willing to negotiate. Most sellers want to work with qualified buyers. Why would they be selling otherwise?
Right.
They realize, particularly on larger deals, that most of these buyers are sophisticated and will have counsel. But if you don't, then you're a sitting duck. So
No kidding.
It doesn't cost anything to go take the time to go to the internet after you take it home and look at it. If they're that much in a hurry to get you to sign something, then it's not a good deal. Buyer beware. Sellers, of course, also benefit from the representation and seller-oriented revisions to the standard TREC contract. Caution. Note to sellers, certain notices to purchasers beyond those in the TREC contract can be required and expose the seller to liability if not given. So when you use the form, it also builds into it liability to the person that's saying they want to use it, because it's telling you have to do certain things, and those are not fill in the blank. So you need to look at that too. Items that can be covered in an addendum include wildlife valuations and filings, representations about environment and governmental matters, indemnity for pre-closing claims and liabilities, unrecorded easements or leases. Very, very important in Montgomery County. Unrecorded easements include that bayou or that waterway or that dry bed that didn't exist until it rained really hard, and then suddenly you've got a lake that you didn't know existed when you bought the property, and they didn't disclose it to you. That may be an undisclosed easement. Maybe you've got the property that you allow them to dredge so that it could be a water flow area, so that this happened in our own subdivision way back yonder, 30 years ago, 20, 30 years ago. The developer entered into contract with an adjacent owner and said, we need a better drainage and the water flows down, but there's a blockage here and there's a natural easement here. Can we dredge where it's built up? No problem. Entered a contract, paid them. So there was a contract, and it created a natural easement. Well, 15 years later, that easement is now all clogged. So the question is, does the subdivision landowner association, who's now not necessarily responsible for it, or the owner that's right next to it, because now their property floods because that dredged land is now full of dirt and sediment and trash or whatever. Maybe they filled it in. Can they do that? No, they can't, because after, I believe the term is, it may be 10 years, but I think for easements it might be 15, and I need to look at that, so don't hold me to it. But after a certain period of time, you have an easement that's been created without it being in writing. So that goes back to Google Earth Pro. You want to look to see if how long, when something was dredged and when it was being used for. And if you buy a piece of property and it looks like the the water is now flowing back into your land, but it's been freshly, it's fresh earth, then it could be that you will have to now, you would negotiate with the seller if you haven't bought it yet. But if you've already bought it, you may have a case if they told you that you can't dredge anymore, to go in there legally and say, this is an easement and you cannot block a natural waterway or an easement that existed, and it won't be of record. So you have to kind of look at that too. So unrecorded easements or leases are critical because you may not know about it. They're not recorded. You got to ask about it, and they may not disclose it. So you want to go kick some tires and talk to the neighbors. Nothing wrong about doing that. Details about any mineral or other reservations, very, very important. To go look at the, you can go to the Texas Railroad Commission and literally just Google to see if there was ever any oil and gas activity out there and if there was any units and what's going on. In the future, it could be that, they find oil and gas, and that's what I did, at all different levels of under the earth. So just because they drilled a well, in 1901 that was, let's say 4,000 feet deep and they unitized it and it's now a dry hole, doesn't mean that there won't be some fracking or something later where they can go 30,000 feet with our technology and they're going to find far more. Yeah. And you've got the center of that unit right there on your property. So you might want to check into that. It doesn't happen very often, but out in Montgomery County it could, especially with large land tracts. Details on personal property, whether it's going to be excluded or not. Details on, like deer feeders are a big thing. Farm and ranch, anything's on that land, it's in that contract, whether it be the tractor. The tractor could go along with it because it's part of the land. Crops that haven't grown yet, those may not be included in the land. So you need to look at that and consider it. Maybe the person selling it has already got a deal where they've already sold those crops.
Yeah, that's
and the
right.
water, too. They may have sold their water rights. Water rights are negotiable. If you've got a lake and you were the one that kept it from the rainwater, it filled on its own, and you've got a water well, which is a big issue with ranch land. If you've got a big reservoir of water and you're pumping away because all the other water is bad, you're like in a Love Canal situation, your neighbor now wants to drill water, but you're draining their water and you're creating a sinkhole in the land next door, and they say, hey, you created a sinkhole, you need to stop that right now. Well, if it was reasonable where you drilled, it's the rule of capture. You can create a sinkhole. If it was reasonable, they need to drill their own, or they needed to protect themselves by drilling their own.
Right.
So that's kind of important too. Water rights. And looking at the land and seeing if it's and looking to see if there's a water pumping next door, if they're going to drain you. Survey and title commitment requirements, due diligence documents, all of these things, and I can go on and on. Environmental issues. These are things that you need to look at and consider in the actual contract. And revise it to account for that if something looks amiss. All right.
So what you've got here defining what default is? Are you saying that default must be specifically outlined in the contract?
Well, yes. Not necessarily. A lot of times it's not, because if something's, contracts have tons of words in them.
Yeah.
Like we've discussed before, I'm a member of a board, and we have our counsel, who is like the guru of all homeowners associations for attorneys. They've written the book, and so we always throw our questions over to them. And these HOA, the covenants, ours were written 40 years ago. And a lot of them were written 20 years ago. Some of them were written only 5 years ago. River Oaks was written almost 100 years ago. So the terms have changed, or they haven't been updated, because there wasn't internet 100 years ago.
Right.
Right. There wasn't a lot of things back then. And so default, when you have terms that talk about, let me see. Default, let's just use that because that was the term you were asking about. Let's say if let's say the contract says, buyer defaults if they don't do something. Well, let's just say it's generic. If buyer defaults, seller it will be will be able to be covered. The buyer has liability. Buyer defaults, liability. Well, what does default mean? So you better. That's a really big one. What does default mean? Because that's the first thing that should come to your mind is, does defaulting mean that I didn't fund it? Does defaulting mean I didn't get my survey done? Those are defined in the TREC contracts. It says that and these are the exceptions for when you can back out. Whether you can back out if you couldn't get funding, was at no fault of your own. You got a certain number of days with an option period. And then if you don't default, because it's an option period, you pay for that option period to look at it first, which I love the options. But default, if you don't define what default is and it's open, definitely look at defining it. But that goes for almost any term. If you don't define easement, we have an easement running through it. Well, what is the easement for? Well, if you don't define it, that easement could be for just about anything, and they can do anything they want on it. So be really careful about these terms that aren't defined. And what is the third big? I know we've got like 10 other things, and we will have to have another show on it. But what is the third biggest thing you need to look at when to a pitfall to avoid when entering a land contract?
Failing to review and scrub title.
Okay, and what that means is you've got to review the title and that title commitment carefully. One of the most common and critical mistakes that buyers make is neglecting to review the title. One deal is the title company generally you'll work through will give this to you, but if you don't have a title company because it's not for sale through a title company,
right,
then you get a landman to go back to the sovereignty of the soil when they first did their the surveys were done, and when Texas became a state, even before that, even when we had Mexican land permits, you go to that general land office and you find out from the sovereignty forward, you get someone to look for it that's an expert to do a title run sheet. Or you're going to be in big trouble because you have to go all the way back to the sovereign, to the patent, and that was the patent that was issued by the state to have actual land title. So anyway, I know that we have to start wrapping up right now. We've just got a few minutes left, but next week's show is going to be a continuation of the other 7 pitfalls and mistakes that you made in entering land contracts. So it's so important. And you make a mistake on this and you can lose so much money.
Oh, no kidding, Tony. All right, guys, we want to thank you for listening. We want to remind you that you can download us on Google Play and iTunes tomorrow, or you can watch us on Facebook Live or recording. And we also want you to remember to
serve God by serving others, and tune in next week because we're going to hit the other 7 major pitfalls to land contracts.
All right. Have a good week.